protections. So now we will see the case laws. Power control appliances with Sumit Machines Limited. 1994 SCC to 448. This case is very important because there are two things. One is that this acquiescence and delay. And another thing is that, like I said in the previous case, he was working with a company and he quit and he started a new company, the previous employer or previous employee. This case is about the dispute between the family members. How a dispute between the family members are being dealt in a trademark matters or in any IP matters. So, in Madras High Court, the plaintiff files three suits. This case is again very important because it is covering the aspect of trademark, copyright, designs. All three IPs are there except patent. This has trademark, copyright, and design. One suit is for complaining infringement of copyright on the image. Number two, a trademark dispute for the name Sumit Mixie. We all would have heard that there was a very reputed brand for mixer grinder, mixie called Sumit. And also they have the design protection for that Viper blade in the mixie. One Mrs. Madhuri Mathur was a sole proprietor of Mrs. Power Control and Appliances Company. She started a manufacturing and power operated kitchen mixie for domestic use since 1963. They are marketed since 1964 under the brand name Sumit. Sumit was the name of the mixie. So they manufacture and sell it. The mixie was packed. This is what very important. So number one is the name Sumit. Number two, the mixie was packed in a cardboard box. On the top, a pictorial photograph displayed the appliance in different colors showing different purpose for which the mixie could be used. The booklet was there, enclosing bearing title Sumit Domestic Mixer Operating Instructions and recipe book. They have a booklet that consisted of 80 pages and bound spirally in hard art paper. A guarantee card was also issued. As such, the first plaintiff is the owner of the copyright. So number one, name is there. Number two, the recipe book and the booklet is there, the manual, how to use the product, all these things were there. The guarantee card was there. The plaintiff claims that he has a copyright over it because it's a literary work. There are two things. One is the literary work and the booklet. Number two, on the cartoon image is there, the artistic work. So the defendant was incorporated in 1984. The company called this Sumit Machines Private Limited. Sumit Machines Private. This was incorporated in 1984 by her own son. It has been manufacturing and selling mainly washing machines and vacuum cleaner from 1991. They started manufacturing domestic mixies exactly similar to the plaintiff mixer with identical specifications except for the power rating. The package and pictorial display are identical. Even the booklet, which was kept inside the packet, the product, is page-wise reproduction. Page-wise, this is very notable. Even the booklet kept in the defendant product is page-wise reproduction, including an error with respect to design. This is what is very important. Like what is a years on copy. So when they copied, even they copied the design number which was there in the plaintiff product. The design number is of plaintiff product. As per the Designs Act, when you register a design, that product should bear the number of the registered design. So that also they copied. The design number of not belonging to the plaintiff. The contents of guarantee card also identical. The first defendant is affixing in each of the appliances the registered trademark Sumit belonging to the second plaintiff in the same artistic manner in which it is registered. Now the issue comes. On these allegations, it was argued that the first defendant has committed infringement of exclusive copyright of the first plaintiff, the artistic material and trade literature displayed on the cardboard box. As I said, the cardboard box, there are some artistic work, the operating instructions and the recipe book and the booklet, manual, everything has a literary work. All these things are copied by the defendant. That is what the argument. With regard to the four components of the mixer, Mathuri Mathur had obtained registration of the design. But blade and other things, they got a design registration as well. The first defendant, Ajay Prakash, is the eldest son of Mrs. Madhuri Mathur. On his return from US, he returned from US. The family business, mainly kitchen appliances of mixer machines, under the trade name Sumit, had picked up by the innovative ideas and dynamic marketing strategies evolved by him. Since he returned from US, he is giving many ideas to develop the business. That is why they give this guy a company. You start a company, you can do marketing work, whatever the idea you do. Initially, it was with the washing machine and vacuum cleaner, but later they also get into the marketing of this mixer grinder, mixie. The family was selling Sumit mixie since 1963. This is what is very notable. The family business started in 1963. This guy, the son, is starting from 1991 or 1980. The first defendant company was incorporated in 1984, Sumit Machine Private Limited. Here again, there is an important point. For starting a company, it's a limited company. If the company has a name which is conflicting a registered trademark, the owner of the registered trademark has to give an NOC to that person so that the ROC, registrar of company, will not raise any objection. It is a compulsory procedure in the ROC when you go for a registration of a company. If the name of the company is conflicting with the registered trademark, they will ask for it. Without NOC, they can never register it. Because the trademark is such a powerful thing that even if you have registered company name, the name of the company itself can be cancelled based on the trademark registration. You can apply before ROC saying that this company name is conflicting with the name of the registered trademark. So they got the NOC also. Since it's a father, mother, son, the father and mother, they gave the NOC to the son. He started a company. For the name, because you can see that the name of the company itself is Sumit. Sumit Machine. So they have a Sumit in the name of the company itself. The said company itself was incorporated with the knowledge and approval of the plaintiff applicant. Then the matter comes to the this thing. The reply of the first defendant is that copyright trademark and copyright design is that of the first defendant, which was conceived by the family company. They are saying that no, Mathuri Mathur is not an individual person. All the works created by the family. It is a family work, so everybody has a right. Being the son of the family, I am also having the right. That is what the argument by the defendant. So he is saying that I am a honest and concurrent use. This is what is very important. What the law says, when you are honest and concurrent, the more than one person can use the trademark. He is saying, no, I am honest and concurrent because I started the company with the consent of my mother and father. She gave a NOC to start the company. My company name itself is having Sumit. So he is saying, I am a honest and concurrent user. I am entitled to use them. Now we will see what the court says. The court says, as I said, there are three elements in this case: copyright, design, and trademark. In the copyright, with respect to the operative instruction and recipe book, guarantee card, the outer carton box in Sumit Kitchen Mixie, vested in the power control appliances, represented by the sole proprietrix of Mrs. Madhuri Mathur. Equally, the copyright in the design registration in relation to the whipper blade was also accepted as belonging to the plaintiff. The trademark in the name of Sumit with the particular artistic design is registered in the name of the Sumit Research and Holding Limited. Again, it's a plaintiff company. Notwithstanding all these, the relief of injunction was not granted in view of acquiescence by the plaintiff, the honest and concurrent use of the first defendant. So the court says, You have a trademark registration, you have a copyright protection because it's created originally by you, you have a design registration. Despite of all these things, you allowed the defendant to use the mark for a quiet period of time. So this will amount to acquiescence. So they are not inclined to give any intervention. Now they go to Supreme Court. Supreme Court, you can see who are, it's a big fight between the learned counsel P. Chidambaram and Soli Chorab. The Supreme Court says acquiescence is sitting by when another is invading the rights and spending money on it. It says you simply sit and watch when somebody is spending money on particular product. You know the knowledge, I mean, you have the knowledge, you know that they are using the brand. It is a course of conduct inconsistent with the claim of exclusive right in a trademark. It implies positive acts, not merely silence or inaction, such as involved in latches. It is important to distinguish mere negligence and acquiescence. Therefore, acquiescence is one facet of delay. If the plaintiff stood by knowingly and let the defendant build up an important trade until it had become necessary to crush it, then the plaintiffs would be stopped by their acquiescence. If acquiescence in the infringement amount to consent, it will be complete defense. The acquiescence must be such as to lead to the inference of license sufficient to create a new right in the defendant. Usually, these are very important wordings. You can just note down and see when you have a view of the judgments in the holy. Usually, the prayer for grant of interlocutory injunction is at the stage when the existence of a legal right asserted by the plaintiff and its alleged violation are both contested and uncertain and remain uncertain till they are established at the trial on evidence. The court at this stage, on certain well-settled principles of administration of this form of interlocutory remedy, is both temporary and discretionary. The object of interlocutory injunction is stated is to protect plaintiff against injury, the violation of his rights for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. Finally says, the court sees why an interim injunction has to be granted and where the balance of convenience lies. It says that the complaint of infringement of trademark is not against Ajay Mathur, but against Sumit Machines Private Limited. This is very important. Why they say it's not against Ajay Mathur? Because Ajay Mathur is the own son. You can see this is a family dispute, but despite of that, the company is a separate entity. Though the company started by Ajay Mathur is a separate entity, it's a private limited company. That is why they say the objection is not for the son as an individual. Mathuri Mathur is objecting the company to use it because initially in 1984 they just used the company for marketing purpose, but subsequently there is a difference between manufacturing and marketing. Manufacturing means creating or manufacturing. Marketing just selling, they are not manufacturing. But the defendant company was just initially marketing. So the plaintiff company took a defense that he is my son, we allowed him, but not to manufacture. He was my distributor, he was just a seller. By knowing that he was selling the Sumit Mixi for the quiet period of time, it doesn't mean that I allowed him for use the trademark. The moment he started using my trademark as a manufacturer, there I stopped. So that will not amount to acquiescence. So I was having the knowledge, he was selling the product as a distributor, as a marketing guy, not as a manufacturer. So there is a difference between manufacturer and marketing. That is what the plaintiff took a defense. And the court says, yes, the complaint of infringement of trademark is not against Ajay Mathur, but against Sumit Machines Private Limited. It is a settled principle of law relating to trademark that there can be only one source, one mark. If there is a trademark, the source can be only one. There cannot be two different sources or three different sources. Either it is a family-owned business or created by somebody. They cannot say the family also can do it, and the son also in a separate entity they can do it. No, that is what the code says. One mark, one source, and one proprietor. It cannot have two origins, where therefore the first defendant respondent has proclaimed himself as a rival to the plaintiff as a joint owner. It is impermissible in law. Even then, the joint proprietors must use the trademark jointly for the benefit of all. Even if the section 24 protects joint proprietors, but even in the joint proprietors, the code says, the law says, they have to use the trademark jointly. One of the proprietors cannot use it separately for their individual benefit. So that is what this code says. It cannot be used in rivalry, in a competition with each other. If you are a joint proprietor, you use it jointly. But in this case, even though it is her own son, he created another company, because the company is a separate legal entity, so he is competing. That is what not allowed. The plea of honest and concurrent user is a very crucial point. As stated in the section 12 of Trademarks Act, is not available for a valid defense in copyright infringement. Honest and concurrent use is only for a trademark. But in this case, they also have a registered copyright. Copyright, there is no such defense for honest and concurrent use. This is what argued by Mr. P. Chidambaram. And again, the court says, we reiterate that when the material on record is available, at present, denial of injunction, once the infringement of trademark, copyright, and design is established, cannot be supported. So they granted an interim injunction. So the rules established in this case are these three elements. Number one, honest and concurrent use, doctrine of delay, acquiescence. This code says honest and concurrent use can be applied only in trademark law, not for copyright. Doctrine of delay, though it is a delay, in this case it was her own son, she allowed it for marketing, not to manufacture. The moment he comes into manufacture, he is a competitor. So the delay will not help in case of this thing. I was waiting for it till he starts his own business. Number three, acquiescence. I have never acquiesced because he was just a marketing guy. He was just selling it. He was a distributor. So these 3 points are covered and distinguished what is acquiescence, what is not acquiescence, what is delay, what is not delay. And there the honest and concurrent use will apply. So these 3 principles are covered in this particular judgment. It's very landmark. So that is what for today, and I